So welcome everybody. This is Alicia Carriquiri, the director of CSAFE. We haven't had a webinar for a little while, so we're all eagerly expecting this one. The three speakers today are Will Crozier from Duke University, then Nick Scurich from University of California at Irvine, and Brandon Garrett from Duke University. And they will be telling us about their experiments with mock jurors and how they understand testimony. And so I'm going to let them take it away without further ado. And I think the order is going to be Will, then Nick, then Brandon in terms of speaking. So go for it.
Great. This is Brandon. I'm going to start by saying a few things to introduce our work together. Let's see if my video will start.
Oh, there we go.
Yes, there we go. Thank you all for attending. It's amazing to see this group of 155 participants.
Thanks.
And Will and Nick and I are thrilled to present this whole family of studies. These are two recent studies, but they build on some earlier work that all three of us have worked on. And so I just wanted to mention a few things about where we are going. We are now in CSAFE 2.0, but these are studies that we were working on in the earlier years of CSAFE. In general, our goal has been to better understand how lay people process and understand expert forensic evidence. And there have been a number of different recommendations in recent years by scientific groups concerning how to make salient and disclose some of the strengths and limitations of forensic evidence. In some situations, courts have been increasingly receptive. Judges have tried to incorporate some of that feedback and have issued rulings on what experts can say. They've been less willing to try to explain science themselves to jurors. Judges have often felt quite uncomfortable being placed in that role. Some of our early work in CSAFE looked at conclusion terminology, and in particular in the area of fingerprint testimony, and at the wording used when experts explain fingerprint conclusions and how lay people perceive them. In general, these have been online jury experiments with large numbers of people taking them. At this point, tens of thousands of lay people have taken these mock jury experiments. And in some of that earlier work, we found that lay people come into a setting with prior views that many forensic techniques are extremely reliable. In fact, we had lay people saying that fingerprint evidence, they gave it higher reliability ratings than DNA. The language that experts use, whether it's sort of a match or to the exclusion of all others in the world, or something more tempered like a reasonable certainty, really didn't impact lay people very much, perhaps because they were walking into this mock courtroom setting with such strong views that this is infallible evidence. But what we found is that if there is any acknowledgement of the possibility that an error can occur, that would cause lay people to be more cautious in how they view the evidence. In other earlier work, Nick and I, along with Greg Mitchell at the University of Virginia, looked at quantitative expressions and what would happen if, rather than use a qualitative language, an expert instead offered a number to explain the strength of a fingerprint conclusion. And so we looked at how mock jurors evaluate conclusions using the FRStat software that the Army Lab now uses. And we found that lay people did actually distinguish between stronger and weaker conclusions. And there were some caveats and some concerns that we raised, but it showed that lay people were capable of making reasonable distinctions between different types of forensic presentations when you move away from words towards numbers. Another study looking at moving away from words towards numbers was some earlier CSAFE 1.0 work looking at proficiency testing information. What happens when you tell lay people about how an expert did on a proficiency test, and does that cause lay people to give more or less weight to the evidence? And we found that lay people were quite discerning and could discriminate between levels of proficiency in a kind of a scenario where they heard this very graded information about how latent fingerprint practitioners performed on proficiency tests. They were much more detailed proficiency tests than would be used in real life. They were scored out of 100. That's not how typical commercial proficiency tests work. The idea was to see whether lay people could make use of that evidence. And we've had recommendations from groups like the NRC or the PCAST report saying lay people need to hear about limitations of evidence. Lay people need to hear about results of black box studies. Lay people need to hear about proficiency of a particular expert. In other circumstances, we've had expert bodies say, well, there are ways to protect against error. There are quality controls that can be adopted, like blinding, but there haven't been recommendations about how to convey that there's a quality control program in place to lay people. And there are just entire disciplines that hadn't been the focus of this type of mock jury research. And so Nick is going to talk about our recent study on firearms evidence. It was just a discipline that people hadn't focused on in the past. A lot of the traditional work on lay people and forensic evidence had been in the area of DNA evidence, because there were so many discussions about how to use statistics in the DNA area, particularly in the 1990s when you had 2 NRC reports on that topic. It was just a very high profile topic. Could lay people understand the complex statistics and the very big numbers involved with DNA? But moving from DNA towards the pattern disciplines and many of the types of forensics that are the focus of CSAFE, there had been very little research. And so our goal was to build this foundation to understand how lay people evaluate this evidence, and then look to whether some of the changes coming out of the courts or coming from the field can improve how we convey information to lay people. So that's my introduction, and kind of wind up to let you know where we're going. We have thoughts on follow-ups to both of the studies that we're going to talk about today, and we'd be really interested in your thoughts on how we could follow up on this research. And with that, I'll turn things over to Will.
All right. Well, thank you for inviting me to come talk about this paper. I'm really excited, and like Brandon mentioned, I'm really excited to hear everyone's kind of thoughts and feedback, especially for future directions. But what I'm going to present on is a set of studies, 2 experiments that I did with Brandon and Jeff Kukuka, who's at Towson University, looking at how jurors appraise forensic evidence when they're given information about blind proficiency testing that the expert did. All right. Okay. So I'm going to go through this really briefly because I'm assuming you're at a CSAFE webinar because you know something about forensics and you know the process. But obviously, human decision making is kind of at the core of a lot of forensic disciplines, and it's relevant and becoming increasingly transparent that it's relevant that jurors understand something about the examiner that's making this decision. So one kind of approach to give jurors information about this is a proficiency test. So the idea behind a proficiency test is you know ground truth. So you can give, say, a fingerprint expert something like this, where they're given an unknown mark, they're given a known print, they're asked to make a match. The administrator of this proficiency test, such as the person in charge of the department, knows what conclusion that they should come to. And generally, this gives us information about kind of how good the examiner is at their job. Are they making a lot of mistakes? Do they come to the right conclusion all the time, most of the time? That sort of information that jurors probably really need to hear. But there's some drawbacks to using a straightforward proficiency test like this. So usually the examiner knows that it's a test, right? The proficiency administrator says, here's your proficiency test, go ahead and take it, let me know when you're done, kind of thing. And there's also concerns over the fact that some of the materials used for these proficiency tests are pretty straightforward and maybe not always representative of what real fingerprints or real evidence matches would look like if you were to come across them in a real case. So their generalizability to the actual work that a examiner would do is somewhat limited. This applies to things like fingerprints, which is what I'm going to focus on today, but really could apply to any sort of forensic discipline as well. So a solution to this is to use what's called a blind proficiency test. And it's blinded in the sense that the examiner, the one completing the test, doesn't actually know that it's a test. So logistically, what this looks like is the administrator of the test will slip in the blind proficiency test to somewhere into the examiner's normal day-to-day work. So they'll maybe be given a print that they think is part of a case and asked to make a decision. And then instead of that going to the police officer that's investigating the case or something like that, the results of that test then go back to the administrator who can judge the performance of the examiner. So the structure of using blind proficiency testing addresses some of the weaknesses that I mentioned with normal proficiency testing, namely that the examiners don't know that it's a test. So concerns over observing behavior or changing behavior or acting differently on a test rather than an actual case are greatly reduced. And because these materials need to be presented in a way that it looks like it's a normal case, they're more likely to be realistic to normal case evidence rather than pretty clearly a test or maybe too easy like some of the proficiency testing. So obviously there's a lot of benefits to measuring performance using blind proficiency tests, but what we don't know is how jurors view this information. Do they pick up on the fact that this is a best practice? Does blind proficiency performance change their view of the examiner or of the evidence, or change their verdicts in a case? And that's what these two experiments measure. So really quickly, I'm going to go through it's worth pointing out here really quickly that there has been one study that looked at proficiency testing. So this is a study by Greg Mitchell and Brandon Garrett published last year. And what you see here is that jurors are somewhat receptive to the idea that better proficiency performance makes for a better examiner, makes for better evidence. So here, the more proficient, right, going from very low proficiency all the way up to perfect proficiency, the more proficient the expert, the more likely the jurors saw the suspect is committing the crime. But it's really quickly worth pointing out that in a control condition in which no proficiency testing was given, the participants, these mock jurors, still see the expert as pretty reliable. So here a score of 8.36 is actually not that different from the perfect proficiency or the high proficiency. So you could have the criticism, right, or a possible limitation to jurors' understanding is that you only are disadvantaged as an examiner, right? If you fail the test, if you do poorly on the test, then your reliability is dropped. But if you don't mention it at all, well, you're just as good as a perfect or high proficient expert. So we, in part, wanted to conduct these experiments to tease this apart and kind of test whether or not that's actually true beyond just this first study. So in experiment one, we started by having a proficiency or a forensic examiner give information about their proficiency test results in the context of a trial. So the expert was either a low proficiency expert, where they say that they got about 6 out of 20 of their proficiency test results wrong. They're a high proficiency expert, where they got a 0 out of 20, so a perfect score. We also had what we call an unsourced high proficiency, where they say, look, I've never made a mistake. They don't have proficiency test results to point to, like 0 out of 20, but they just say, based on their experience, they've never made a mistake. And then we have them talk about or make no mention to proficiency testing. So they just deliver the evidence of the case, talk about their examination of the evidence, never say anything about the proficiency test. So this proficiency information is embedded in the direct examination of the expert. So the expert would give their conclusions or describe their method in the case, give their conclusion, and then talk about their proficiency or not in the case of the no mention control. So after reading the examiner's direct examination, we then gave our mock jurors a questionnaire. So for those of you that are familiar with experimental design, this is a 4-group design: low proficiency, high unproven, and control. I want to point out that actually in this first experiment, we actually varied the evidence type as well. So for half of our participants read this structure for a fingerprint expert, and the other half read it for a bite mark expert. Somewhat surprisingly, we didn't see any differences between ratings or any of our outcome variables for fingerprints versus bite marks, which is maybe kind of troubling on its own. But for the sake of this presentation, I'm just going to collapse all the results here. So if you read the paper, you do see this extra variable that we manipulated, but because there's no difference, I just collapsed all the results that I'm going to present today. And we recruited about 1,400 participants online to serve as our mock jurors. So just real quickly, so you know what the results I'm going to show you are. In the questionnaire, we had them deliver a dichotomous verdict. So how would you decide guilty or not guilty based on the examiner's evidence and report? We also asked them a continuous measure of what we call an estimated likelihood of commission, or ELOC. This is basically from 0 to 100. How certain are you that the defendant in this case committed the crime? So a score of 100 would mean they're completely certain that this is the person who committed the crime. We would expect these to overlap, obviously, with the dichotomous verdict, but the continuous measure gives us a little bit more precision in the measurement. We asked them to make ratings of the examiner, so how skilled they are, how scientific you think they were, as well as ratings of the evidence itself. So how strong was the evidence, how scientific was the evidence. And then we also included a couple kind of what we call instructional manipulation checks and attention checks, just to make sure that our participants are paying attention. So we make sure that we're getting good data from these people, even though they're doing it online. All right, so turning to our results, I'm going to show you first the verdicts, results, and then the ELOC results, which again, they're going to look very similar because they're basically tapping into the same construct. But what we see is in a low proficiency expert, so somebody who's made 6 out of 20 mistakes, we see about 65% of our participants still convict, which is high, but fortunately significantly lower than a high proficiency expert, right? Which is convicts about 80% of the time. So jurors are picking up on the fact that a high proficiency expert is probably giving you a more reliable analysis than a low proficiency expert. And we see that same trend here with the ELOC, that continuous measure. However, whenever we compare these results to our unproven and our control conditions, we're actually replicating the previous study by Brandon and Greg Mitchell, showing that people who don't make mention to their proficiency testing or just say, hey, I'm really good at my job, I've never made a mistake, are seen as about as reliable as your high proficiency expert. So these unproven and control groups are significantly higher than the low proficiency, but they're not significantly different than the high proficiency, which is kind of problematic because we want somebody who can point to a number about how good they are at their job to be seen as more reliable than somebody who just says, I'm good at my job, but I don't have any evidence. So in experiment 2, we wanted to follow up and make this a little more realistic by including a cross-examination, right? So the idea that, especially if you have a low proficiency expert, a defense attorney is not going to let that go. They want to talk about it. They want to draw the jury's attention to it and make it more salient for them. So what we did is we took our experiment 1 design and we tweaked it a little bit. So we dropped these 2 control conditions because they were very similar to the high unsourced. The high proficiency, the 0 out of 20 on the proficiency test. And we added in a middle phase here between the direct examination and the questionnaire, where we asked, or we showed them a cross-examination. So the cross-examination was either a testing cross-examination, where it just asked about blind proficiency testing in general and asked them about the results. We included a testing and subjectivity cross-examination, which has that testing element about how well they performed on their proficiency test, and pointing out that their work, that fingerprint analysis is subjective and involves a human error. So this is what we consider really strong cross-examination, or a control condition where there's no cross-examination whatsoever. Then participants would take the questionnaire. This is a 2x3 design, so we vary the proficiency either high or low, and then whether they get the testing cross, the testing and subjectivity cross, a strong or no cross whatsoever. And then just for good measure, we left in this hanging control group where they make no mention to the to the proficiency testing and they don't get cross-examined. And we recruited about 1,400 participants again online. So the results I'm going to show you here are a little more complicated, but I can walk you through them. So looking first at the verdicts, we see a similar pattern to what we saw in the first study, where the low proficiency expert, that second bar, is the lowest. The control condition is a little bit higher than that, and the high proficiency expert is seen as the most reliable, or leading to the most verdicts. We see this same general pattern for the estimated likelihood of commission. But something we found here that's really cool, I think, is that at least for verdicts, so not so much for ELC, but at least for verdicts, the control condition was seen as significantly lower than the high proficiency. So it does seem like in some circumstances, juries will look at a high proficiency expert that can point to their proficiency test results and see that expert as more reliable than a control condition, which is a motivation for more departments to use blind proficiency testing. When we look at the effect of cross-examination, we see that cross-examination has quite an effect. So here, whenever we give them the testing or the stronger testing and subjectivity cross, we see verdict rates go down pretty precipitously for our low proficiency expert in both of these measures. Same pattern here. But compared to the high proficiency expert, the effect of cross is actually diminished. So in the low condition, right, for say verdicts, you see conviction rates go from about 70% all the way down to about 35%. However, in the high condition, verdicts go from about 85% down to only about 70. So it's less harsh of a decrease where this cross-examination is maybe less effective. And we see the same trend for ELC as well. So this gives us evidence that a high proficiency expert is actually somewhat inoculated against the effects of a cross-examination. It really takes a really strong, forceful cross-examination to significantly drop these results or these verdicts compared to the low proficiency expert, where even a weaker just testing cross-examination can drop verdicts. I'll also point out here, I don't have graphs for it, but I'll point out that the ratings of the expert and the ratings of the evidence all kind of follow this trend as well. So it's not just that the verdicts are dropping, but participants are seeing both the expert and the evidence as less reliable, as less credible, as less scientific, as proficiency goes down and as cross-examination is introduced. All right, so that was a lot of graphs. So I can summarize it for you pretty briefly. So we kind of take this as mostly good news for everyone involved. So we see that low proficiency sometimes hurts an expert a little bit, right? You see a little bit of a drop in verdict and ELC and in ratings. So this is, evidence that that low proficiency experts aren't as good at their job as maybe a high proficiency expert, and jurors pick up on that. But we also see evidence that high proficiency sometimes helps a little bit, right? It increases over that control condition, and it can inoculate you against the effects of cross-examination, right? So only a strong cross-examination really hurt the high proficiency examiners, whereas low proficient examiners were hurt by all of the cross conditions. But it's worth pointing out that overall, these are still pretty small effects, right? So even a low proficiency examiner is getting convictions or getting guilty verdicts, 60%, 70% of the time. So it's not like we're seeing huge swings here, but maybe just enough kind of to go in the predicted directions. But the takeaway here is that jurors can differentiate between good and bad examiners, especially when we're giving them a cross, and especially with blind proficiency information. So I have a couple limitations here. I'll just go through, and I'm curious for you guys' thoughts to this. So we think that maybe proficiency may matter less if other evidence is involved. So if you start introducing maybe DNA evidence or multiple forms of evidence, that might decrease the impact of blind proficiency testing. We can't directly observe crossing proficiency about a no proficiency expert, right? Like a really clear implication here would be, well, what if somebody doesn't do blind proficiency testing and you ask them about them? We can't observe that from these results. We also think that competing experts may complicate things, especially if they have varying levels of proficiency. But these are all directions for future research as well. So if you're interested in the paper, and I'll wrap up with this slide, it published this year in Forensic Science International. Here's the citation. And if you're interested in pre-registration or our data or our materials, all of that is available in the Open Science Framework. So you can just follow this OSF link here and find kind of all of our background work. So with that, I will stop. Thank you for your attention, and I'll turn it over to Nick.
Great, thanks so much, Will. And Nick, while you're coming back into the screen sharing, thank you for the questions you've posted already in the chat. We'll kind of turn to all the questions once Nick is done, but these are really useful questions.
Can you hear me? I think should be good. So good morning or afternoon or night. I don't know what time it is here even. I got finished teaching last night very late. Thankfully, the quarter is coming to an end. So I'm going to talk very briefly about a couple studies that are focused on firearm and tool mark evidence. It's something that I've kind of been involved with for a little while now. And one thing that's interesting to me is how courts have been responding to different scientific critiques about the validity or the reliability of fire examiner testimony in courts. One thing that I've noticed is that no court that I'm aware of has precluded firearm examiners from testifying at all. Instead, what judges tend to do is what you might say split the baby, and they kind of hedge. So rather than excluding this testimony altogether, they'll try to impose limitations on what the examiner can actually state with respect to his or her conclusion. And so just to give you kind of a flavor of what I'm talking about, I've pulled out a few cases, and this is by no means, a complete list. So in trying to kind of temper down the language a firearm examiner used in this, well-known case in Diaz, the firearm examiner was allowed to testify that the bullet from the crime scene was identified to a reasonable degree of ballistic certainty, right, as having come from the defendant's gun. And this idea of ballistic certainty was different than scientific certainty, supposedly. And that was, thought to kind of convey to the fact finders that this isn't, quite the same level as scientific certainty. It's ballistic certainty. This was kind of an offshoot of this idea of medical certainty. Another well-known case, Glenn, the examiner was limited to saying it's more likely than not that the bullet came from the crime scene. And then there was a recent case in DC. In interest of full disclosure, I testified in this case for the defense. But in that case, the judge went at the time probably further than any other judge and held that the examiner would be allowed to testify and only allowed to say that the firearm could not be excluded as a source of the shell casings found at the crime scene. So this is all very interesting. I'm a psychologist. I immediately wondered, does any of this matter to fact finders? And typically what we're talking about here is members of the lay public who are kind enough to actually go down to the courthouse when they're summoned and survive voir dire. And so that was kind of the genesis of this project that's been going on for a little while now. Do these variations in language actually matter to jurors? Will and Brandon and I finally got around to publishing this paper. It just came out in Law and Human Behavior. I'm happy to send you a copy of the paper if you'd like. I'll have my email address at the end. So, a very simple empirical question: do these variations and other variations actually matter? So in this study, we had a relatively large sample, and I'll say more of, about this in a second as to why we had such a large sample. But it's kind of just the standard mock juror simulation. We gave them judicial instruction on the presumption of innocence, the reasonable doubt, what their task is, and ultimately these individuals, who are all jury eligible adults in the United States, I should add, rendered a verdict of guilty or not guilty. The case we kind of modeled the materials off of involved an attempted robbery at a convenience store. Basically, the guy walked into the store, fired a gun into the floor, said, "Give me all the money." Sometime later, a defendant stopped. The same caliber gun is found in his possession. And sure enough, a firearm examiner tested a bullet discharged from the defendant's gun and determined that it matched the bullet that was recovered from the convenience store. And so the materials consisted of kind of the backstory, as well as a direct examination of the firearm examiner, who explained, that he followed the AFT method, that he has quite a bit of experience in this domain, and that ultimately it was a match, but what we manipulated was the conclusory language the expert used to describe that match. And so it could have followed one of 7 possible conditions, right? So in one condition, they were told, actually, it's just inconclusive. There was not sufficient agreement among the characteristics to make a determination one way or another. Another condition was just a simple identification. I identified the bullet as having come from the defendant's gun, right? Another iteration was this ballistic certainty phrase that I mentioned earlier. We had the more likely than not phrase or formulation. Another iteration, and this came from a different court case, is that the analyst testified there was complete agreement, okay, between the characteristics, and I'll say more about this in a second as well. We also use the Department of Justice recommended language. And finally, we use the language from Tibbs, which was that the defendant's gun could not be excluded as a gun that discharged a bullet from the crime scene. So kind of a small technical point, but I think one that is very important and worth mentioning. You may have noticed that the sample size was quite large, particularly for psychology studies, right? So we had about 200 people in each of these 7 conditions. We had hypothesized essentially a null effect. In other words, the variations in language here would not have much of an effect at all. And so it's, incredibly important to have sufficient statistical power to detect an effect, because if you don't, you might fail to reject the null hypothesis. And then that's ambiguous because you could either be rejecting the null hypothesis, meaning there's no difference between these groups, either because you don't have sufficient power to detect differences, or perhaps there are no differences as we were hypothesizing. So that's kind of a side technical note as to why we felt it very important to pay a lot of money for this unusually large sample, okay? So just cut to the chase, what did we find? On the y-axis, we have the percentage of guilty verdicts in each condition. So in the inconclusive condition, about 20% of people still voted to convict. That might be, troubling for reasons unrelated to the forensic evidence, but it's actually not uncommon. I've run so many jury studies at this point, and for some reason, you always find, 10 to 20% of people just assume that if formal charges are brought against a criminal defendant, that there's, they're defendants for a reason. But it's kind of a side note. So when there was just a simple identification, the percentage of guilty verdicts jumps way up. And what you'll notice is that there's no difference across the different formulations used to describe the match. So consistent with our hypothesis, these tweaks to the variation, these tweaks to the language used to describe the match do not appear to have their intended effect. Although if you look at the Tibbs formulation, cannot exclude, then you see a significant decrease in the amount of guilty verdicts. So it appears that, the judge in Tibbs, his, as far as I know, it was his original formulation, this cannot exclude language. And it does appear to have its intended effect. Whether that effect is large enough or not is a different issue that we don't address here. So there's an important qualification to this study, which is that, there was no cross-examination, right? This was just direct exam from a firearm examiner. And so we ran a second study in which we included cross-examination. And I'll give you kind of a flavor of what this looked like. We culled this from a couple different cases, and we had some actual practicing attorneys review it to tell us, is this realistic at all? Is it strong enough? What would you say? I'll come back to that point in a second. So here's what the cross looked like, and this is what the participants read in this study, right? You examine the crime scene bullet and the defendant's gun, correct? Yes. That required some interpretation, didn't it? Well, yes, there's always an element of interpretation. It wasn't a perfect match, was it? There were clear points of comparison on which there was consistency, but there were differences when you compared the bullets under the microscope, right? Well, there's always differences, but in my judgment, those differences were not meaningful differences. So just to be clear, you're saying that there are differences, individual differences between the crime scene bullet and the bullets fired through the defendant's gun. Yes, but you don't consider those differences to be meaningful in your words. As I said, there are always some minor differences when you compare bullets under a microscope, but a number of individual characteristics were identical. There aren't any formal rules in your field about what constitutes a match. You just rely on your own personal judgment. There is no formula for what constitutes a match. I rely on my knowledge, training, experience, right? So it's a match because you say it's a match. Yes, I'm an expert. Okay. Have you ever committed an error in your work? No, I've passed all my proficiency tests with perfect accuracy, never made an error. You ever read a scientific study that reports an error rate? Maybe. I think they find error rates between 0 and 1%, but my error rate is 0%. Are you aware of the PCAST report, which said firearms analysis is not scientifically valid? No, I have not read that report. Are you aware that mainstream scientists don't consider firearm examination to be a science? No, I'm not aware of that, and I don't agree with it. Right. So that was most of the cross-examination. And so what did we find? Again, we find that when there is an identification, the guilty verdicts jumps up to around 60% compared to when, it's an inconclusive response. The cannot exclude decreases the percentage of guilty verdicts. So this is a partial replication of study 1, right? Replication's important in science and in psychology especially. But what we find is that across all 3 of these conditions, cross-examination does not have an effect at all, right? And you see that because the black bars are not statistically or practically different than the gray bars, right? And so I'll just end on this note with what I thought was a really kind of prophetic observation or even just hypothesis. And this is a judge from the Tibbs case. So one, argument for this type of evidence is that it should come in, right? And any issues with kind of error rates and proficiency testing and things of that nature should go to the weight of evidence, not the sufficiency of it. And what that basically means is that these are all issues that should be brought out on cross-examination, right? And that's typically the argument that's put forth, that this is not perfect science, but that's, those are things the jury should consider. And in Tibbs, the judge actually said, I don't think cross-examination is going to be able to cure any of these issues because this discipline is just too far complex for a series of questions to allow a full understanding of the limitations of the field, right? And he said, it'd be fanciful to conclude that the normal adversarial process would enable a lay jury to adequately understand these issues. And I think our second study largely corroborates that, that observation, that cross-examination did not have an impact at all. Now, of course, you could counter by saying, well, maybe that cross wasn't strong enough, or I would have done it better, which I've now heard from a few different attorneys. And, I say, that's great. Continually testing things and looking to see, if cross-examination does have an effect, what the boundary conditions are is an endeavor that should be undertaken. But, based on the data from this study, it looks like this observation is correct, that it's just not enough to cross-examine experts, firearm experts on the stand. So I'll end there. I wanted to leave as much time as possible for questions. If you want a copy of that study, you can email me and I'll send it to you. Thanks.
Great. So we have a number of questions. Maybe we could try to take some of them. Some of them we've answered here and there in the chat. And please send us more questions as you think of them and as we discuss all of this. One question was, what does the term ballistic certainty mean? I've not heard anyone use that before. That is a good question. What is a reasonable degree of ballistic certainty? Presumably it refers to the level of certainty that allows the expert to have a reasonable degree of ballistic certainty. It's a somewhat of a circular phrase that, that some judges seem to have settled on. You know, one theme in some of these decisions is that judges are themselves struggling to come up with something that they think is appropriate to tell jurors, short of, you know, only this firearm could have discharged that casing to the exclusion of all others in the world. Or if you're not going to make an extreme statement of an identification, then what is the more qualified language? And if the field hasn't supplied one, then what is a judge supposed to do? And so judges are kind of reaching around. I assume they got the idea of talking about some sort of a reasonable certainty from a totally unrelated context in the medical testimony area. Judges will often say that an expert must testify to a reasonable degree of certainty based on the field of medicine in which they practice. It's kind of a term of art in medical malpractice suits to ask experts to testify in that way, which absolutely does not reflect the way that, you know, doctors would talk about their field or their practices. It's kind of a judicially imposed thing. I see some questions on, was there any indication in the studies that the jurors actually understood the science that was being presented to them? Or were they basing their decisions on the believability of the witness? So did they actually understand the methods, or was it just the believability of the witness? I think we could add some other things that jurors might have been basing their decisions on in addition to believability or an understanding of the underlying science.
Yeah, so I can jump in and add here that I provided a little bit of an answer to the question in chat already, that we use some attention checks and manipulation checks to make sure that, you know, people at least kind of understand the facts of the case and what's going on. It's worth adding that, you know, when we talk about these experimental designs, the only thing that will vary between participants is the specific thing that we change. So an overall point is, you know, do jurors understand the science itself, or are they just relying on the likability of the expert? There's been some studies that, you know, show that likability or character of the witness or those sorts of things are relevant, but the jurors do at least somewhat understand the science. And, you know, I think both of these studies actually show that jurors maybe understand that to some extent. But I suspect that the fact that, you know, we don't have 100% conviction rates for a high proficiency expert means that they're at least still kind of questioning something. We do have ratings. I alluded to the fact that we have like ratings of the expert, you know, ratings of the evidence, and those all kind of track together. So I kind of take that as evidence that yes, they are considering the character of the witness, or, you know, how likable they are, how reliable they are, how reliable they seem to some extent. But because of our experimental controls, that's not the only thing driving the differences we see.
Yeah, I should add that in some studies that I've done, I varied conditions where we have a version where the expert gives a much more detailed description of the method and just goes into finer detail about the steps involved and how it works. We haven't found that causes lay people to place a lot more weight on it. That may be more the case for those were studies looking at fingerprint testimony, and it may be that people walk into a situation placing so much weight, they've heard so much about fingerprints that they just don't care what all the steps are. It may be that for other methods where people haven't heard as much about it, that hearing how it works and what the procedures are that are used may have more of an impact. In that context, though, we didn't find any particular effect of having a more detailed explanation of the steps used in the discipline. One other question is, were participants given instructions similar to jurors in real cases? We do give a reasonable doubt instruction. So we're not just asking them, you know, 1 to 10, do you like the expert? they are being told that if you are going to vote guilty, this is the standard that you need to hold yourselves to. Let's see. Another interesting question that we just got is, whether you could have a study using deliberation. And so jurors could use their understanding of the testimony to influence other jurors, to talk it through. We were very interested in looking at that. And obviously, it's not just a vote where each individual person votes whether they would convict or not. It may be that their initial thoughts on whether they would vote to convict or not are really important. And there are studies suggesting that your view of the strength of the evidence is most important in deciding as a juror whether you would convict or not, and that individual jurors' assessments of strength of evidence do correspond strongly to the group decision eventually to decide what to do as they reach a judgment. But other dynamics certainly affect deliberation. And we've been talking about designing. The deliberation studies are very time-consuming and expensive and burdensome to implement. You think about it like, you need to have however large your jury is, more than 6, at least 12, maybe you need alternates. If someone logs off the Zoom, then is the experiment over? Do you need to have an alternate there in the room? You have to have a moderator there, since our IRBs will not just let strangers, meet with each other in a Zoom room unsupervised. But we also think that it would be extremely interesting to not just see whether the ultimate decision to convict on balance is different when you have deliberation, but also to record and to analyze what the lay jurors talk about. What are the themes that are most important to them? What do they talk about when they are weighing what the appropriate response is to expert testimony? Do they just focus on the expert's credentials or how believable the person seemed? Or do they walk through some of these issues having to do with methods and what are the strengths and limitations of the method? Do they talk openly about, come on, we all know that this stuff is great, I've seen it on TV? Or do they say, well, wait a minute, let's listen to what this expert said and what the responses were to the lawyer's questions? I think that will be really interesting work, and we've been working through some designs. We want to make sure we take our time and design anything like that carefully, because those studies are very time consuming and very expensive. Another question has to do with, does it make a difference whether jurors read the testimony on paper or whether they hear and see the testimony? And we've definitely done some experiments where there's video of a witness delivering the testimony. We didn't see strong differences. There are, but I think it does raise interesting questions. Are people better able to focus on what the expert is saying and thinking if they can read it? Or do people pay more attention if they see someone's face and see their manners and someone is delivering the words in a way that's more compelling and easier to follow? Will, you were just answering some questions about how we recruited these people, and I think that might be interesting for folks in the audience to hear about. We're not just using, as our sample people who thought it'd be fun to take a study.
Yeah, I think, so we recruit off of online panels. So we try to make sure that we're recruiting. Obviously, you can see in all the experiments that we run, we try to recruit a lot of people, just to make sure that we can control for and address, small variations and individual differences that we're not interested in studying. We do try to get nationally representative samples, especially in terms of race. And we get a pretty good spread of ages, of backgrounds, of income. So we do have a more diverse sample than maybe, like college adults that sometimes you see in other psychology experiments. I'm trying to find some of these like methodological questions because I think they're really important and I think that's worth answering. To Sharon's question, I think that yes, we are trying to make sure that our participants are paying attention. We assume that if they're not paying attention, then blind proficiency testing, for example, right? That's not going to matter if they don't even notice it or don't even think about it. So kind of our goal in a lot of these experiments is to say, all right, under a best case scenario where people are paying attention, where they don't have a ton of evidence to process, where they're not getting bored or falling asleep, that they can remember the evidence, do these sort of manipulations work. How well that translates, I think, into actual practice is a different question. I think that there's some limitations of that. But this is all kind of preliminary, promising work, I think, right? The idea that it can work, you just have to make sure that it's in the right context.
See, a couple of additional questions just came through. One was, has there been work looking at the effect of opposing experts? Greg Mitchell at UVA, who's been the co-author on a couple of our earlier papers, and I have a paper coming out soon. It's under review right now, looking at what happens when there's a battle of the experts and looking at different types of rebuttal experts, whether it's an expert that actually looks at the evidence and comes to a different conclusion, or an expert that just says, you need to understand that there's some limitations to this method. Let me explain the method in more detail, but not an expert that is actually examining the evidence. And we see that it does make a big difference to have a competing expert and actually a competing expert of both types, whether it's an expert. I think we could all understand how it would be impactful to have an expert actually come to a different conclusion. Then you have disagreement about what the underlying conclusions are that can be drawn from the facts. But we also saw that it was quite impactful to have an expert speak to methods, which is the kind of expert that Nick has been, speaking to limitations of methods, but not looking at casings under a microscope. We also had some questions about what implications these have for forensic science standard setting bodies. I think in general, we haven't had standard setting bodies test the language that they're recommending for testimony on mock jurors. And this isn't a problem special to forensics bodies. Judges all the time draft jury instructions, often relying on lawyers like me, law professors, members of the bar, draft us some jury instructions to explain something clearly to jurors, and they never test it out in any experimental way on actual jurors. And so there is a terrible problem of whether it's judicial instructions or professional associations coming up with recommendations for testimony, choosing words that lay people don't understand in the intended way. There have been increasing recommendations from standard setting bodies that certain subjects be explained in testimony, that you can't just testify without explaining the strengths and limits of your evidence, without explaining uncertainty. It's obviously extremely important in CSAFE, since we're a statistical center as well as a statistics and law and forensic evidence center, that uncertainty be explained. And in the past, you had categorical conclusions, where experts would not discuss any sources of uncertainty. What this work is doing is exploring, well, okay, if you're going to talk about uncertainty, how do you talk about it in a way that's understandable? And I think I think will also be helpful. Some of the standard setting bodies have said, well, you need to acknowledge uncertainty, but they haven't said how. Even the PCAST report said, well, you need to talk about proficiency, you need to disclose error rates to the jury, but it didn't get into how. Perhaps because there wasn't a body of evidence looking at what are the possible ways you could explain this to lay people, and what are the ways that seem to best inform jurors. And so it may be that standard setting bodies can reach these questions once they have a larger body of research to rely on. Certainly from these studies, one theme is that standard setting bodies have said a lot about conclusion words. Should you be saying, should you not be using individualization, and instead be talking about identification? We shouldn't be using the word match. The FBI stopped using the word match, almost 20 years ago. These studies suggest that those sort of final conclusion language words don't matter as much as the words used to describe the limitations of the method. That whatever your terminology is for whether it's identification or a source identification or whatever it is, people may assume that what you mean is it came from that thing, unless you say something else about what level of uncertainty there is, what are the limits of the conclusion. On the flip side, there's also a set of lessons here for labs and practitioners, to the extent that labs, for example, were worried that if they adopt blind proficiency testing, examiners would be burned if they ever made a mistake on a test. That's not what we're seeing here. We're not saying that lay people are horrified by the possibility that someone in a testing environment would make an error. Perhaps they get that, no one scores 100% on every test, and that is a good thing to test people. So that's a positive message in the sense that, we want, error is not something that whether it's practitioners or courts should be afraid of. It's something that to be embraced as part of the regular work of experts and the conveying of evidence and reports and conclusions, and that jurors don't, throw up their hands and say, I don't believe in anything anymore when they hear that error occurs. Instead, they weight the evidence differently, like we would want them to.
I think I'll jump in real quick, Brendan, and add that really quick that it seems like there's a lot of discussion about kind of the quality of cross-examination and the value of cross-examination. I think that those are all really good points and probably deserve more research focusing on them. I think, like what makes for a good cross-examination is something we don't have a lot of empirical evidence on. I responded to a comment that especially in the studies that Nick presented, we see that if a expert is still confident in the face of a cross-examination, they might actually look more reliable because they've stood up to that scrutiny, right? So what makes for a good cross, and whether the extent to which lawyers know how to craft those crosses, I think is a really, really important question that I think involves both, as suggested, working with lawyers to figure out what they know and what they would consider, as well as putting it to the test to see if it has the desired effect on mock jurors.
There's a great question that just came in, that proficiency tests not only tell you something about an individual examiner, but that to varying degrees, some tests are really about testing the laboratory and the entire quality control process. Sometimes a test is directed towards an individual person to take the test. Sometimes it's directed towards individual examiners, but they're allowed to take it in groups. And so it does tell you about a group process as well. We haven't looked at the type of sort of lab quality control proficiency test and how that information impacts jurors. I think that could be really interesting. We did, right, in some of the conditions in the blind proficiency study, though, there was discussion by the expert about why having this program was good for quality control and why it said something positive about the lab, that they have this larger quality effort that this testing is a part of. And I don't think we know specifically whether that was what impressed jurors or whether that played a role. That jurors thought, oh, this is a lab that's going above and beyond to try to assure quality, but that may have been part of what jurors saw when they saw that testimony.
I'll just quickly respond to Sharon's comment about the no proficiency or never been wrong being just as high as a high proficiency. I think that it is kind of surprising, but I think that it makes a lot of sense in the light that lay people probably walk in with pretty high respect for forensics examiners. I think they see them as scientific, they see them as reliable. They're probably kind of already at the ceiling of how credible that they are. And I think that it takes a lot to drop that down. So unless you specifically give people evidence that they should rely on an examiner less, then they just assume that they're really good at their job and that they should rely on them as much as possible.
Great.
I think, do you see any other questions to respond to, or do you think we're trickling down.
I think maybe we're trickling down. Let's see.
There's one more. Let's see. Oh, great presentation. Yeah. You did address some of the Q&A questions, right? In addition to the chat ones.
Yeah, I think I responded to some of them via chat. And I think the ones that I didn't,
Okay.
I think Brandon might have spoken to already.
So for the participants, if you'd like to listen to the talk again, this has been recorded and will be posted on the CSAFE website, www.forensicstats.org. And that's going to be up within a day or two, I think. Slides as well. Do you guys contribute the slides so that we can post them? And references and so on. So I think without further ado, we thank the speakers and we thank the audience. This was really a great talk. Stay tuned for our next webinar. I believe it is in February or January. I don't. Somebody from CSAFE jump in, please. Well, we don't know. Anyway, so happy holidays to everybody, whatever it is that you celebrate. Better 2021 for everybody, I hope. Couldn't be much worse than this one. And thanks again for a fantastic talk. We'll be in touch.